Hello LiveLaw viewers, welcome to Courts Today. Let us dive into the important legal headlines of the day. The Supreme Court has today set aside dismissal of the two lady judicial officers in Madhya Pradesh and called for sensitivity towards women's difficulties. Archaeological Survey of India has informed the Allahabad High Court that the Sambhal Mosque is in good condition and there is no urgency for repainting it. The Apex Court has held that stay on discharge orders should not be granted unless circumstances are exceptional. The Apex Court has dismissed a PIL over the New Delhi railway station Stampede. Delhi BJP government has withdrawn the Aam Aadmi Party government's plea in Supreme Court against direction to sign MOU with Centre on PM Abhim. The Kerala High Court has observed that alleging rape on false promise of marriage is baseless when complainant lady was already married and not divorced. The Supreme Court has dismissed Tamil Nadu Pollution Control Board's plea against Isha Foundation and barred coercive steps against yoga and meditation center constructions. The Kerala High Court has held that selling train tickets booked from IRCTC platform for commercial gain is punishable under Section 143 of the Railways Act. The Supreme Court has granted pre-arrest bail to former Chhattisgarh Advocate General Satish Chandra Verma in the NAN scam case. And the Rajasthan High Court has quashed a notification creating a village against guidelines barring names based on caste or religion. I'm your host Urvashi Chauhan, bringing you the important legal updates of the day, quick, crisp and to the point. Watch this video till the end, and if you find this update valuable, please do not forget to like, share and subscribe to our channel. Starting with an important update, the Supreme Court today set aside termination of service of two women judicial officers from Madhya Pradesh after finding it to be punitive, arbitrary and illegal. In 2023, 6 female judges were simultaneously terminated from their service by the Madhya Pradesh government. This decision was based on the recommendation given by the Administrative Committee of the Madhya Pradesh High Court. Last year in January, the top court took a suo moto cognizance of this and directed the MP High Court to reconsider the decision. A full bench of the High Court then agreed to reinstate 4 of the 6 judicial officers. Therefore, the other 2 judicial officers, namely Sarita Chaudhary and Aditi Kumar Sharma, came before the Supreme Court. A bench of Justices B.V. Nagratna and N.K. Singh heard their plea and reserved its judgment in this matter in December last year. During the hearing, it was found that both lady judicial officers were on probation when they were terminated from service. In Aditi's case, it was argued that her termination was made on the adverse remarks made against her during assessment. But this was communicated to her after termination. Also, the High Court, while considering her termination, failed to accommodate that she suffered from mental and physical health issues after she went through an abortion. As for Ms. Sarita, it was argued that her termination was primarily based on various complaints filed against her, including where she posted something on Facebook. Today, the top court has directed their reinstatement within a period of 15 days in accordance with the seniority they possessed. The court directed the MP government and the MP High Court to declare the probation of 2 officers as on the date their juniors were confirmed. The monetary benefits of the period of termination shall be calculated notionally for the purpose of pensionary benefits. As regards Aditi's case, the court noted that during the period of probation, she got married, got diagnosed with COVID and suffered a miscarriage. Also, her brother got diagnosed with cancer during this period. The court therefore held that the adverse remarks in the annual confidential report were made without considering these factors. The top court held that the High Court ought to have considered these issues with sensitivity. As regards the other officer, the court noted that no opportunity was given to her to respond to the complaint alleged to have been pending against her. This judgment, authored by Justice Nagratna, also elaborated on the physical and psychological difficulties which women face in judiciary. She has stated that miscarriage has a serious effect on the physical and mental health. After the pronouncement, significantly, Justice Nagratna said that we need to be aware of the anxieties and difficulties which women face. She said that they take tablets, medicines to kill pain on certain days of the month to be able to sit from morning to evening. Following the directions of the Allahabad High Court issued yesterday, the Archaeological Survey of India today submitted an inspection report stating that the Shahi Jama Mosque in Sambhal is structurally in good condition and there is no urgent need for repainting it. If you recall, the Masjid Committee has approached the High Court to carry out some maintenance activities ahead of Ramzan. The ASI's report has, however, stated that the Masjid Committee has undertaken several works of repair and renovation in the mosque, resulting in addition and alteration of the historic structure. According to the report, the floor of the monument has been completely replaced by tiles and stones. The interior of the mosque has been painted with thick layers of enamel paint of sharp colors like golden, red, green, and yellow, concealing the original surface of the monument. The report adds that at the west and north sides of the mosque, several small chambers exist which are used for storage by the mosque management, and the same are in dilapidated condition, with ceilings supported by vulnerable wooden shingles. As far as day-to-day maintenance such as cleaning, removal of dust, and removal of vegetation growth in and around the monument, etc. are concerned, the ASI said that it shall undertake the work provided the Masjid Committee cooperates. The Mosque Management Committee has, however, disputed the ASI report, insisting that whitewashing is necessary. Justice Rohit Ranjan Agarwal today granted the committee time till Tuesday to file its response or objections to the ASI report. In the meantime, the court has ordered the cleaning of the mosque premises, including removal of dust and vegetation both sides around the area. In another important judgment, the Supreme Court today held that high courts should not ordinarily stay the discharge orders passed by trial court in criminal cases. Sikh leader Sudarshan Singh Wazir had challenged a Delhi High Court order that stayed his discharge in a murder case and directed him to surrender. The case here relates to the 2021 murder of former National Conference MLC Trilochan Singh Wazir. Sudarshan, who was the president of Jammu and Kashmir State Gurdwara Prabandhak Board, is one of the accused. In October 2023, the trial court discharged Wazir and 3 co-accused while retaining charges against 1 accused. The prosecution then approached the Delhi High Court to challenge this decision. In November 2024, the Delhi High Court stayed the trial court's discharge order and asked Wazir to surrender, stating that he could not benefit from an order that was under appeal. However, the court clarified that he could still apply for bail, which would be considered separately. A few days later, the Supreme Court took up Wazir's plea and put a temporary hold on the surrender order. It also paused the trial proceedings against him. Justice Oak had at that time questioned whether a discharge order could even be stayed, calling it completely unheard of. During the hearing, the Supreme Court had questioned the impact of Delhi High Court's ex parte stay on Wazir's discharge. It pointed out that stay effectively subjected Wazir to trial without setting aside his discharge, calling this absurd. It noted that this situation put Wazir on trial despite the fact that he had already been discharged. Also, the Additional Solicitor General Rajkumar Bhaskar defended the High Court's decision, arguing that it was based on prima facie finding that the discharge order was flawed due to non-application of mind and resembled a mini trial. Today, the bench of justices Abhay S. Oak and Ujjal Bhuyan delivered its judgment on Sudarshan's plea. The court said that stay on discharge should never be granted unless circumstances are exceptional. It further said that even when someone has been acquitted but the prosecution challenges the acquittal and the court decides to arrest them during the appeal using section 390 of CRPC, they should normally be given bail instead of being detained. In the next update, the top court bench of Justices B.R. Gavai and P.K. Mishra today dismissed a PIL filed in relation to the Stampede which occurred at the New Delhi railway station on 15th February, leading to several deaths. The petitioner here, Anand Legal Trust, argued that not all deaths had been accounted for and that many families were yet to receive compensation. It claimed that videos and eyewitnesses' accounts suggested a higher death toll than officially reported. The petitioner also highlighted that stampedes were becoming a recurring issue and accused the railways of issuing notices to remove videos related to the incident. But the bench refused to entertain the matter, asking the petitioner to approach the High Court. The bench said that it was open for the affected persons to approach the court. I must tell you here that last week the Delhi High Court had sought response of the Union government and the railways in a plea seeking measures to prevent stampede at railway stations. The BJP-led Delhi government has withdrawn a case from the Supreme Court that was originally filed by the previous Aam Aadmi Party-led government. The case challenged a Delhi High Court order directing the government to sign an MOU with Centre for implementing PM Ayushman Bharat Health Infrastructure Mission in Delhi, also known PM Abhim. This issue dates back to 2017 suo motu PIL in the Delhi High Court, which highlighted the shortage of ICU beds and ventilators in government hospitals. In response, the High Court ruled that Delhi must implement the PM Abhim scheme, especially when 33 other states and union territories had already done so. The court had emphasized that the scheme would benefit Delhi residents and should not be delayed even due to a model code of conduct. It also questioned why the Delhi government had not taken steps to improve critical care infrastructure. Challenging this order, the AAP government had moved the Supreme Court. Their counsel, Senior Advocate Abhishek Manu Singhvi, had argued that health is a state subject and the High Court's direction redefined the division of powers between the centre and the state. He also pointed out that under the MOU, the centre would bear 60% of the capital cost but 0% of running cost, potentially burdening the Delhi government. Singhvi had further claimed that Delhi's existing healthcare scheme had a wider reach compared to PM Abhim. The Supreme Court, after hearing the plea, had issued a stay on the High Court order last month. However, after the BJP won the Delhi Assembly elections, the new government decided to withdraw this petition. Today, Advocate Jyoti Mendirata, appearing for the New Delhi government, informed the court that the administration was moving forward with the implementation of the scheme. Taking note of this, the bench of Justices B.R. Gavai and Prashant Kumar Mishra allowed the withdrawal. The Kerala High Court has ruled in a case that the offence of rape on false promise of marriage does not apply when the complainant was already married and continued in that marriage at the time of the alleged offence. The case here involved a police officer who allegedly promised to marry the complainant, had multiple sexual encounters with her and also took around 9.3 lakh from her. He was charged under the IPC Section 342 for wrongful confinement and Section 376(2)(n), that is repeated rape on the same woman. Seeking to quash the charges, he approached the High Court. In his defense, the accused claimed that he initially intended to marry the complainant but withdrew after learning that she was already married and had 2 children, as a legal marriage was not possible. The High Court has ruled in favor of the accused, holding that since marriage was never legally possible, the sexual relationship was consensual. Justice A. Bahaduruddin observed that in such cases, the promise of marriage itself is an impossibility. For the charges to stand, it must be prima facie shown that consent was obtained through a misconception of fact, which was not the case here. The court explained that while obtaining consent for sexual intercourse by falsely promising marriage could amount to misconception of fact, but the situation here is different because the complainant is already in a valid marriage. The court further stated that in such cases, the very promise of marriage is baseless and therefore there is no misconception involved. While dismissing a petition filed by Tamil Nadu Pollution Control Board, the Supreme Court has today directed that no coercive steps should be taken with respect to construction of Sadhguru's Isha Yoga and Meditation Center at Coimbatore. With this, the Supreme Court refused to interfere with the Madras High Court order, which had quashed the show cause notice issued to the foundation for carrying out construction work at Villiyangiri Hills, Coimbatore between 2006 and 2014 without obtaining environmental clearance. The bench of Justices Suryakant and N.K. Singh approved the High Court's view and dismissed the Pollution Control Board's challenge. On the previous hearing, the bench had asked as to why the board had challenged the order after a delay of 2 years. The bench had also orally remarked that Yoga Center was entitled to the exemption as an educational center. Today, while dismissing the appeal, the court clarified that the present case should not be treated as a precedent for regularizing illegal constructions. It also clarified that for any future constructions, it was imperative for Isha Foundation to take prior permissions as per law. In another update, the Kerala High Court has ruled that procuring and selling train tickets booked through IRCTC website for commercial purposes is a violation of its terms and conditions. In this case, a petitioner who is a travel agent approached the court seeking to quash criminal proceedings against her for allegedly booking and selling online train tickets without authorization. She was charged under Section 143 of the Railways Act, which prohibits unauthorized ticket procurement and resale. Justice Manu, relying on a previous Supreme Court decision, held that Section 143 applies to e-tickets as well. The court found that the petitioner here had used multiple IRCTC profiles to book and resell tickets at higher prices making a profit in violation of IRCTC's personal use policy. The Central Government Council argued that IRCTC's terms explicitly prohibit commercial resale and only authorized agents or railway servants can legally sell train tickets. The petitioner here, however, claimed that any registered IRCTC user can book tickets for others and that it could have simply deregistered her account instead of filing a case. But the court, after reviewing terms and conditions of IRCTC, ruled that the website is strictly for personal use and commercial exploitation of the platform is illegal. It concluded that a prima facie case was made out. It dismissed her petition and directed the petitioner to face trial. Moving further, the Supreme Court has today granted pre-arrest bail to former Advocate General of Chhattisgarh Satish Chandra Verma in connection with the Nagrik Apurti Nigam scam case. This case involves allegations under the Prevention of Corruption Act and IPC. The state alleges that incriminating WhatsApp chats between Verma and prime accused Anil Tuteja and Alok Shukla were recovered by the Income Tax Department and shared with Enforcement Directorate. It is further alleged that Verma helped the accused to secure bail. The former AG had filed an SLP challenging the Chhattisgarh High Court order denying anticipatory bail to him. Senior Advocate Mukul Rohtagi, representing Verma last week, had argued before the top court that he was being targeted due to a change in the government in November 2024. He pointed out that the bail granted to the accused in 2019 was never challenged by the state until now. He also stated that Verma did not prepare any legal replies or appear in this case. Last week, the top court had issued notice and directed that no coercive action be taken against him. Today, the bench of Justices Vikram Nath and Sandeep Mehta granted him relief. And lastly, the Rajasthan High Court has quashed a state notification that created a new revenue village named Gogaji Ki Jal in Barmer district. The court ruled that the notification violated 2009 state guidelines which prohibit naming villages after a person, caste, subcaste or religion. Justice Vineet Kumar Mathur in his order has also struck down all similar notifications issued by the state. The court observed that Gogaji is a local deity worshipped by a particular community, making the naming non-compliant with Clause 4 of the 2009 guidelines. The court here was hearing multiple petitions, including one that specifically challenged a notification dated 20th January 2025, creating the village. The petitioners argued that while the state government has the power to create new villages under Rajasthan Land Revenue Act, the guidelines clearly prohibit names linked to any individual or community. The High Court agreed and ruled that the state's notification violated Clause 4. As a result, it quashed the notification along with all other similar notifications. It has also clarified that the order applies only to the petitioners who approach the court but will also cover cases where notifications are still in process.